Dr. Bruce W. Dearstein and Henry M. Greenberg, Esquire, for our program, Who Owns a Photo of Your Face? The Right to Privacy and the Courts. Dr. Bruce Dearstein is a former professor at the University of Maryland and former program director at the New York State Archives. He has written dozens of articles on archives, history, and related topics, and is the author of 9 books, most recently the second edition of The Spirit of New York, Defining Events in the Empire State's History, and The Crucible of Public Policy, New York Courts in the Progressive Era. Bruce has also been a contributor to New York Archives and is a longtime member of our editorial board. Henry Greenberg is a shareholder at Greenberg Traurig LLP and vice chair of the Historical Society of the New York Courts. Hank is also past president of the New York State Bar Association, the largest voluntary state bar association in the nation. A former counsel to the New York State Attorney General, general counsel to a major New York State agency, and federal prosecutor, Hank has handled numerous high-profile matters. He concentrates his practice on civil litigation, criminal and civil investigations, and regulatory and administrative law. This program is co-sponsored by the Historical Society of the New York Courts, which is celebrating its 20th anniversary this year. Founded in 2002 by Chief Judge Judith S. Kay and her associate Judge Albert M. Rosenblatt, the Society achieves its mission of preserving, protecting, and promoting the rich legal history of the state through public programs, student initiatives, publications, oral histories, exhibits, and other novel projects that highlight the role of New York's courts in society. There will be a question and answer session at the end of the presentation, so for those of you who have joined us today, you can feel free to submit questions throughout the presentation using the Q&A box at the bottom of your screen, and we will do our best to get to as many of those as we can. And without further ado, I am pleased to introduce Bruce Dearstein and Hank Greenberg.
Thank you so much for that introduction. And we're going to turn to our expert in authority, Bruce, in just a second. But let me just say a word or two about Bruce in addition to the introduction you just heard. We are all incredibly fortunate because we're going to be hearing from, truly, I think today, the leading historian about New York State government and politics, writing on that subject. And for those of you who are not aware, Bruce is also the author of what I happen to think is the most significant contribution to the history of the New York Court of Appeals and its history in quite some time, The Crucible of Public Policy, New York Courts in the Progressive Era. One chapter of this fabulous book, which chronicles the work of our state's highest court, the Court of Appeals, during the Progressive Era, the first 2 decades and the latter part of the 19th century. But it's a magnificent book, and I recommend it to anyone who has any interest in New York history, New York politics, and most notably the work of the Court of Appeals in the early 20th century. This afternoon, we're going to be talking about Roberson versus Rochester Folding-Box Company. And I will just say, one of the deepest thinkers of New York law, in addition to Bruce, and an expert as well on the Roberson case, my good friend Dan Kornstein once said of the Roberson case, just as we sometimes see a world in a grain of sand, so too we can occasionally see much of the legal universe in a single case. And I think that can fairly be said of the Roberson case, a decision of the Court of Appeals from 1902. So Bruce, let me turn it over to you, and perhaps we can start this discussion by you telling us about the Roberson case. What was it all about?
Well, thank you very much, Hank, and thanks to the sponsors of this webinar. I very much appreciate it. We're going to talk about the 1902 Court of Appeals case in Rochester versus Roberson versus Rochester Folding-Box Company, decided 1902. And this is important for at least three reasons. One, it's about the intersection of technology and policy and public law, issues still with us. Secondly, it's about the power of the courts to make so-called judge-made or common law through their decisions. And third, a lot of the research that I did, both for this and the rest of the book, is from the Court of Appeals archival records in the state archives, where you find the briefs of attorneys as well as the final decisions. So could we have slide 1, please? This is the technology. This is an ad for Eastman Kodak around the first couple of years of the 20th century, highlighting their Kodak camera invented in Rochester in 1888 by George Eastman. There were millions of these sold very quickly. They were easy to use, simple, cheap. Lots of people had them, photographed families and social events. And they also went to commercial photographers, and there were thousands of these shops by the turn of the century. But this meant a couple of other things. One is you could photograph people without their knowledge or without their approval. And secondly, because of the commercial photograph studios, you might have a photo that was particularly interesting that you could sell for advertising, or you could feature in a news article or something of that sort. And women in particular were exploited through this situation, including the First Lady of the United States, Frances Folsom Cleveland, latter part of the 19th century, whose photo was used in ads for soap and pianos and other products. Well, how could this be? This is terrible. Well, there's no law against it. It's not illegal. People can do it. Now we look at the next slide, which is similar to what you saw going in. This is what started the Roberson case. This is it. There's not a whole bunch of these or variations. This is it. This shows Abigail Roberson of Rochester, and you'll see this is a Rochester case. The technology's out of Rochester. The companies are in Rochester, right nearby, and the litigant is also in Rochester. She was about 16 or 17 when this photo was taken, and it never became clear where it came from, who took it, how, whether with her permission or not. Probably taken at a commercial studio, and she probably gave a copy to a friend who passed it on to the company, Rochester Folding-Box Company, which made posters, flyers, and ads and boxes for Franklin Mills Flour, which is just over the county line in Lockport. So here it is, the flower of the family. There's a little play on words here because young women were sometimes referred to as flowers or beautiful flowers. So in any case, Franklin Mills presumably hoped this was going to help them sell flour. Well, it wasn't illegal. Courts had wrestled with this some, and they had not been able to find that there was in the Constitution, or state or federal, a right to privacy which would prevent this. And the state legislature had taken this up in the 1890s and was unable to agree how to proceed, and so dropped it. But Abigail's mother went to court in Rochester and sued for $15,000 in damages and a court order forbidding any further use of this photo. And much to some people's surprise, the state Supreme Court, that's the court of first resort in the New York state system, in Rochester held in her favor that she had a constitutional right to privacy. And the Appellate division, because the company's appeal, also held in her favor. That took it to the Court of Appeals, the state's highest court, in 1900. So by then, it had become a very high-profile case. Two intermediate courts had, in an unprecedented way, found a right to privacy in the Constitution, which other courts had not found. There was a lot at stake. She succeeded a very high fine, which would have amounted to about $500,000 today, $15,000 in those days. If a portion between the two companies probably would have bankrupted them bankrupted them both. And the case had additional high profile because the chief judge of the New York State Court of Appeals, all but forgotten now, but a prominent judicial statesman in those days, was Alton B. Parker. Already, by the time the case actually came before the court and was decided by the court, 1902, already the front runner for the Democratic presidential nomination in 1904, which at length he would achieve, losing to Theodore Roosevelt.
Bruce,
So,
could I just jump in for 1 second? Now, correct me if I'm wrong.
Uh-huh.
My understanding was that the lower courts, as well as in the Court of Appeals, that counsel for Ms. Roberson weren't arguing that there was a constitutional right to privacy, but were arguing that New York's common law, which is subconstitutional, should be extended to embrace a right to privacy that could be the basis for a lawsuit for money damages. Would you agree with that characterization, that they weren't arguing that the Due Process Clause of the Constitution, and we'll talk a little bit more about what the United States Supreme Court is dealing with, but am I right that we're really talking about common law, not constitutional law, at least in this case?
I think it's accurate to say we're talking mostly about common law, but some about constitutional law. Because common law, which is so-called judge-made law, is based upon a reading of the Constitution and previous court decisions and laws and so on. In the 1890s, a couple of courts, New York State courts, had come very close to saying there was a right to privacy inherent, kind of by implicit in the Constitution, but they hadn't quite said it. One court said that the courts could find such a right if they wanted to, but this was a moot case because the person at issue had died, was deceased. And another court issued an order forbidding further use of a woman's photograph, but stopped short of saying that there was a common law or constitutional right to this. Now, I should have said at the beginning, I'm not an attorney. I'm a historian, and so as I did research for this case and my book, I tried to learn a lot, and hopefully I learned enough that I've got this right. And my impression in many of these cases was the counsel, whom Hank mentioned, who, by the way, in both sides of this case were outstanding, and that tended to be the case in these days, and I think now, of everyone who appeared, just about everyone who appeared before the Court of Appeals. Some of these counsel cast as broad a net as they could about constitutional law, common law, and so on. And in the case of Roberson, her counsel further said, well, this has caused her mental anguish, which it had because friends teased her about being in the ad. And in fact, she got physically sick for a while, which you can imagine, because she was a young woman and never had been exploited like this. And so there's a little bit of argument about, well, her health demands that we do something about this. But all that said, I agree with Hank's comment. Yeah, there's mostly a search here for a common law precedent, and the first two courts finding enough to go with her, and then it comes to the Court of Appeals.
Could we spend a second, Bruce, talking about the New York Court of Appeals circa 1902? What was its reputation? How was it perceived in the state and nation?
Sure. Well, in my opinion, it was then, maybe still is, the most important state court in the nation, second only to the U.S. Supreme Court and its importance and prominence. In those days, many important cases didn't make their way into the federal system and then up through the appellate system there. They started in state courts. They were decided in state courts. State courts seemed to be where much, maybe most of the action was. And it's no surprise that New York was so prominent, because in this time period, about 1900, about 1920 in particular, we're talking about New York State, which was the first to experience massive industrialization, urbanization, immigration, and so on. And therefore, the first state where these problems reached an issue, or these issues reached a level where the legislature was forced to confront them. Now, in the case of privacy, they didn't confront them. They didn't confront it. In the 1890s, they considered privacy and found it too hard to deal with. Those will see they're going to deal with it pretty soon. They're going to have to. But in other cases, the state legislature passed regulatory laws, and they came up first and in a very high-profile way before up through the New York State hierarchy to the Court of Appeals. And perhaps the best example is the example of the so-called New York Bake Shop case, which involved a New York State regulatory law dating from the 1890s, as a matter of fact, regulating the hours and conditions of bakers, which came up through the courts, was decided in 1904 in the case of People versus Lochner, in a decision written by Chief Judge Parker, that this was constitutional. It didn't violate due process or anything else, totally within New York State's rights. Very, very important decision, only to be reversed the next year by the U.S. Supreme Court, which was very conservative in those days, in the very, very famous case, still discussed today, of Lochner versus New York. And by the way, the judge who wrote that decision, Rufus Peckham, not a well-known name, Rufus Peckham was also a New Yorker. He had come up through the Court of Appeals. In fact, he knew Parker. I don't think they were friends, but they happened to know each other. So quite a few of the big issues of the day kind of came to roost here first in New York, dealt with in New York by statute, and therefore decided or appealed to the courts and decided by the courts first here in New York.
So,
Go back.
okay, so the stage is set. New York's highest court, the most esteemed state court in the nation, certainly at that time, second only to the U.S. Supreme Court in terms of prestige, is about to hear this case in which Ms. Roberson's counsel is asking the court to break new legal ground, to recognize a common law right of privacy for which she could sue to recover damages and stop this box company from using her image. And lawyers, as they will, are writing briefs trying to persuade the Court of Appeals to see the case their way. In addition to the lawyers' briefs, was there another sort of source of analysis or commentary that played a role in this case in the Court of Appeals?
Yeah, that's fair to say. The briefs which I saw for this and other cases I researched were outstanding. They were long. One of the cases I researched, the briefs were 1,000 pages. All the briefs together, more than I might have liked. So there was that. There was the lower court's decisions, which were always thoughtful, but there was in the legal literature, though not in the not so much in the law or the common law so far. There was in the legal literature some discussion among scholars, if you will, and professors and leading lawyers of the day who published in journals, that there was a common law right to privacy. And the most prominent of these was an article called The Right to Privacy in the Harvard Law Review in 1890. Still worth reading if you're interested in this. It was written by two attorneys in Boston, Samuel Warren and Louis Brandeis. Now, Samuel Warren was an outstanding attorney, had a great career, and Louis Brandeis went on to become a labor attorney, a reformer, and eventually a Supreme Court justice, outstanding for the positions he took for the most part, and in the way he wrote. But in this article, they said, look, there's a right, what they called it was, there's a right to be let alone. And that's kind of in line with the common law's long protection of the right to life, the right to property. It's right there, it's inherent. It's one of the things the courts have done in other settings and ought to do here. They said instantaneous photographs, particularly in newspapers, which they were more concerned with than they were with ads like this. Instantaneous photographs are a new sort of invasion. An image, one of the things they wrote is an image is a representation of the person. And so stealing the person's image is kind of an assault on the person. But they also set some limits, and they were very thoughtful in the way they discussed it. If you look at that article in turn, it drew on some other law texts and law articles of the day, other discussions going on at the time. So it's probably fair to say, without exaggerating or generalizing too much, the best legal scholars of the day and some of the leading attorneys of the day, which Brandeis and Warren would fit both categories, they were kind of ahead of the courts. They were kind of beckoning. They were sort of writing things which, if we look back on it now, and maybe we'll have a chance to talk about this later on in light of recent decisions by the U.S. Supreme Court, we see them as amazingly kind of leading edge and before the time. So yeah, there was a body of literature, if you will, that sort of was in advance of the courts on this.
Yeah. Just one comment from me, from the perspective of a legal historian. The Brandeis-Warren Law Review article was an oh wow moment in the history of the influence of American academic publications in courts, and presaged the future use of law review articles, like so much of the Roberson case, in other litigations. And to your point, I'll just say, Bruce, what you said, Louis Brandeis is one of the most outstanding justices in the history of the United States Supreme Court. That comes 12, 14 years later. And the idea that these two lawyers in private practice write an article published in the Harvard Law Review, then as today, one of the most prestigious law review articles, that it drew so much attention in a court case was an extraordinary thing in its own right. But let's go back to the Court of Appeals. What happened?
Well, just real quick before we go on. My understanding of this is it was not so much Brandeis who initiated it, it was Warren. And that was because he had married into a prominent family, and they were harassed by newspapers. They wanted photographs and published things about them which weren't true. And his wife happened to be a friend of Francis Folsom Cleveland, who had been exploited in the same way. And he was kind of outraged about this and went to his law partner, Brandeis, who wrote most of the article, but didn't quite have as much invested personally as as his co-author did, although later on he certainly had a good deal invested in these sorts of cases. Yeah, maybe can you get the next slide, please? You may not recognize, those of you who are watching this, Alton B. Parker, but you would have in 1902 because he was famous. I suspect that if you ask people in the street, which nobody did, his name was better known probably than the name of the Chief Justice of the United States. Not because of his legal work, somewhat maybe, but because by then people understood, look, he's probably going to be nominated for president, which he did, which he got. So in any case, in 1902, when this finally got to the court and everything was all settled, Parker wrote the decision for the court, majority decision. The court had 7 members. This wound up being a 4-3 decision, not what the chief judge would have liked. He would have liked it to be unanimous, but it wasn't, and he didn't try to force people. So he rejected her suit. He said it's not in the Constitution, and there isn't a common law right. Well, what about the right to privacy? He specifically cited the Warren Brandeis article and said, well, that's nice. That's academic. That's kind of fanciful. It's a concept invented by legal scholars. It might be nice to have a right to privacy, said Parker, but there isn't any. There's nothing concrete that he could find in the Constitution, state or state or federal, rather. Nor in previous court decisions. There's not enough, Parker said, in common law. And Parker, was not willing to lead his court into a kind of uncharted territory, making a new decision, which would then be cited by others. He said that hurting someone's feelings is not really a crime. And in fact, he made what looks to us now like a facetious remark, didn't intend it that way, that perhaps Abigail Roberson should be pleased, even flattered, that this company had found her picture attractive enough to use it in their ads. So that comes across as, at best, paternalistic, and maybe at worst, something not quite as good as that. But he also said that, look, if we allow this, we're going to open the floodgates. There will be lots of other people here suing because their photo's been used in the newspapers or for ads or whatever, and that would overwhelm the court. We can't have that. But at the end, he said, now look, this is a matter for the legislature, not for the courts. So common law, which Hanks alluded to a number of times, which he sure knows a lot more about than I do, is sometimes referred to by lay people as quote unquote judge-made law. That is, pronouncements which judges and courts make on the issues of the day, and it's happened many times in New York and American history, based upon their reading of the Constitution and precedents and the tenor of the times and the situation at hand and the evidence that's been presented. Parker said, this is not our business. The legislature has got to deal with this. It's not up to us. Now, when he said that, it wasn't specific, but I know he had in mind the fact the legislature had taken this up in the 1890s and had decided not to deal with it because they discovered it was hard to identify what privacy was. The newspapers opposed anything that would maybe prevent them from using personal information and photographs. And so the legislature, in effect, had kind of taken the hot potato and passed it to the courts, assuming that sooner or later somebody would bring suit and it would make it to the Court of Appeals, and hopefully the Court of Appeals would take care of it. Well, now the Court of Appeals, through Judge Parker, in effect, not to trivialize it, was tossing the hot potato back to the legislature. So 3 of Parker's colleagues agreed with him, giving him 4, but 3 did not. And in this era, progressive era, in New York State Court of Appeals at least, it wasn't uncommon at all to have a divided court. When that happens now with the U.S. Supreme Court, 5-4, we think, well, that's terrible. It shouldn't happen. It shows whatever we think it shows. But it was pretty common, at least in this particular court, in those days. Okay, next slide, please. Now, you may not recognize this fellow either. This is Judge John C. Gray, who wrote the dissenting opinion on behalf of himself and two other judges, opposing what Parker had said. And again, if you're interested in this issue of privacy and common law and so on, you read the Warren Brandeis article, which, as Hank has said, is something of a classic, well written, well constructed. But also go back and read Judge John C. Gray's dissent in the Roberson case, which seemed to me, even as I was reading, even more startling, because something like it could have been written yesterday. And Gray said, look, what these companies did is a species of aggression. It should not be allowed. It's just like coming up to somebody on the street, in this case, a kind of defenseless young lady, and assaulting her. It's terrible. And he said, among other things, the law is made up largely of judge-made law. A very striking sentence, meaning, look, the honest fact is most of the way we proceed, the way we're governed, the way the courts act, is based on previous decisions of the courts. And he would say, as some people did, look, the legislature, first of all, is incompetent to deal with all of these things, doesn't have time, and sometimes just doesn't get it right. I mean, later on, Parker and some of the other judges said, well, look, the legislature takes pot shots at things and passes too many laws. That was going to come a little later. So a dissent is 4-3. Chief Judge and his colleagues on one side saying no. Gray and his two colleagues on the other side saying yes.
Just one quick observation. Your description of the decision of the majority and the views of the dissent, I think, aptly present why the Roberson case is taught in law schools throughout the nation today, all of the time. Because those competing views are as relevant and as pertinent and as important today as they were in 1902. You could just tick off the various flashpoints between their two views, and you can understand why those were two remarkably strong arguments, almost equally balanced. The common law, right? It can expand. It can be extended by courts based on new technology, new innovations, contemporary mores. Whether to expand the law or not is a judgment call. Judge Parker thought in the majority, no, we don't want to extend it. The dissent said we should. This debate about should the court do it or the legislature, we hear that all the time, right? Judges, it's sometimes described as judicial activism versus judicial restraint. Judge Parker argued for restraint. It's for the legislature to do, not the courts. Judge Gray said, no, it's for the courts because we are vested with the responsibility of making common law. This idea of floodgates bursting open if the court recognizes a new course of action. You see that argued all the time in courts today. If they recognized a right to privacy, how many new kinds of theories and cases and expansions of that doctrine would we see? So long story short, Bruce, I think you brilliantly sort of captured those two views, and fundamentally, right, they were both right in the sense that they were arguing points of view that had wisdom and merit. And then there was this judgment call, which is why we pay judges to judge, about how to do this.
Yes.
4 said one thing and 3 said the other. What happened? What happened after the court handed down?
Well, I just to underline what you just said, I think it often comes down these days, and in those days, to a judgment call. And that's why the chief judge is so important, because sometimes there isn't much of a record of this. The chief judge sort of tried to convince his colleagues to go in a certain direction. He didn't push them hard, but he sort of led them that way. So a progressive chief judge might kind of point in one direction, and a conservative chief judge might point in another. Yeah, so this decision's made, 1902, 4-3. Parker might have wished it otherwise, other people might have wished it otherwise, but what does this mean? Well, two lower courts had said she had a right to privacy, but the highest court, but only by a vote of one, majority of one, said she didn't. But that majority of one was important because the chief judge had written the opinion. So what happens? Well, there's a great public outcry about this. This is the first time, I believe, in New York State at least, when you find a fair amount of criticism of the court. This was kind of unheard of in the days prior to this. And the newspapers in particular criticized Parker and his colleagues for not protecting the rights of this innocent young lady. So this case was not about an adult. I think she was 17 by the time this finally got decided. It was about somebody who was kind of defenseless, which kind of added to the poignancy of it. But in any case, back it goes to the legislature. 1903, they feel pressure to do what they had not done before, and they take up the issue of privacy again, and they find, just as they did in the 1890s, it's pretty hard to define. And the newspapers, which had opposed going too far in the 1890s, and it turned around and criticized Parker for not taking care of this in the court, turned around again, in a sense, and opposed having the legislature go too far, because that would have meant, it could have meant, look, you can't use a prominent person's photo in the newspaper or write something salacious or inaccurate about them without their permission or without going to them first. So the legislature passed a law which said basically that a person or a company that uses another person's image for commercial purposes without having first obtained their consent is guilty of a misdemeanor. No specific penalty indicated. People who felt that their rights had been violated, though, could go to court and apply for a restraining order and damages. So some people may think, that's it? That's all that they did. Well, that is all that they did, and that law, I think exact wording, maybe some slightly different change, slightly different wording. That law is still in the books today. New York State still has that law and some others relating to privacy, but still doesn't have a quote-unquote common law right to privacy. So what happens here? Well, probably no surprise. This isn't very long before the new law is challenged in court. And up it comes to the New York State Court of Appeals. By then, Parker had run for president, was defeated. Goes to the Court of Appeals, and the Court of Appeals okays it. They say this law is constitutional. It's not really common law, right to privacy, but this law, narrow though it may be, this is constitutional. They appeal to the U.S. Supreme Court, which thus far hadn't been a player in this particular story, and the Supreme Court agrees. So that's the way that went.
Bruce, just a few observations with what you just described, which I find so interesting, and I think many people looking back at this case. So the media outcry, the public outcry with the majority's decision, we can understand because intuitively there seemed to be an injustice here. A woman's image was used by a commercial actor to make profit and money based on her appearance without her consent. And I'd venture to say virtually any person you would meet would say that's not right. So the media, editorial boards, the public are not happy. But what's so interesting to me about the legislative debate, and I think Judge Parker made this point even in his decision, was he said, okay, you don't like this outcome. How broad is this privacy right going to be? Because as soon as it got in the legislature, the media said, oh my goodness, you're not going to sue us if we have a picture in a newspaper of a member of the public, are you? We're a newspaper. We try to make money selling newspapers. That can't be unlawful. And the legislature agreed with the media. And so they drafted this narrow law to address a very specific perceived injustice, cabining this privacy right in a way that I think, looking back on it at the end of the day, makes one ask the question, we don't have to answer it now, was Judge Parker wrong to say, let the legislature do this because they can draw these lines carefully? Whereas a court, if the Court of Appeals just recognized the common law right, you could be sure there would have been other cases, media would have been sued, others would have been sued, and eventually the court would have had to draw on those lines. In any event, yet another reason why we're talking about Roberson more than 100 years later. Did Ms. Roberson get the last laugh, if you will, at the end of the day?
Yeah, well, next slide, if we could. Yeah, Abigail Roberson actually left Rochester for a while, but then came back and lived out the rest of her life there. In fact, among other things, taught piano lessons. And here she's pictured late in life at a piano. And I'm sure she would be appalled if somebody had told her she'd understood at some point, anybody who wants to can see this image. It'll be up on the internet. She wouldn't know what that was. But yeah, she did get the last laugh, I think, because in 1904, Parker ran for president. Newspapers took his photo, including one where he lived in Esopus near Kingston. He used to swim early morning in the Hudson River, and he was emerging one day. I mean, he had a nice bathing suit on, so it wasn't improper, and somebody took his picture. And they took some other candid pictures of him, put them in the newspapers, and he complained. He said, this isn't right. This is my privacy. People shouldn't be able to take my picture and put it in the paper. And she wrote, Abigail Roberson, wrote a letter to the editor of the New York Times, again, still worth reading, saying, well, Mr. Democratic nominee for president, I have it on good authority that you have no such right. And here's the authority, the opinion you wrote 2 years ago. And it wasn't quite a good fit because they weren't trying to use Parker's image to sell something that is a commercial purpose, which would have been illegal, at least in New York State by then. But they were using it as part of their news coverage. So, yeah, I think she had the last laugh in a sense. This law that we're talking about, you might call it the Abigail Roberson Personal Privacy Law, though it's not called that. Today, if a law passed like that, where laws are sometimes informally, casually named after the people whose incident in life or episode in life it's designed to commemorate or remember, it might have been called that. But after this passed in New York State, advertisers cut way back on their unauthorized commercial use of photos in ads, and some other states copied New York's law, pretty similar. But other states didn't, and this gets off to what Hank was alluding to a little while back about common law. In some other states, there is a common law right to privacy. It's based on judicial decisions. And a number of courts looking to New York for guidance, as courts tended to do in those days, looked not to Parker, who was really prestigious in 1902, 1904, less so in 1905 because he had lost the presidency. In fact, the election never ran again. They looked to Judge Gray, and they found inspiration in Judge Gray. And then looking back of him along that intellectual track, if you will, back to the Warren Brandeis article. So there's a bigger story here about the common law right to privacy as it played out in the states. And I just want to repeat quickly, I think I said it at the outset, in my period at least, 1900 1920, the big issues of the day seemed to play out in the state courts. Some of them reached the Supreme Court on appeal from the state's highest court, but many of them didn't. They were settled at the state level.
Maybe we should spend a few minutes talking about the legacy of Roberson. Let's just start in New York courts. How has that decision fared in the Court of Appeals over the next 120 years?
Well, it's fair to say, Hank, you're better suited than I am to answer this. As I understand it, actually from you, because I didn't research, and again, I'm a historian, not a lawyer. I didn't research this much past 1900, or 1920 rather. But my understanding is that the law is still there, and this is guiding law. The case, I think I just learned this from you, as a matter of fact, or it's been driven home. The case is still good law. There still is no right to privacy in common law in New York State, as there is in lots of other states. And it is still a question for debate, and you still see things written about it, and you can expect to see that continue. Well, gee, New York State ought to have a broader protection here of common law. So, if I got that, right.
I think you nailed it. It's really so interesting. I think for the contemporary reader, if they picked up the Roberson case, many of the themes you've described, they would see, cogently argued in the majority and the dissent. A lot of the language is, by contemporary standards, I think we would say not acceptable. There was suffused with, as viewed in 2022, language that would be blatantly sexist if used in a judicial opinion today, in terms of, the discussion about Ms. Roberson and her feelings about the use of the photo and all of that. But the holding of the case, the core holding of the case, which is there is no common law right to privacy in New York, that has been reaffirmed by our state's highest court over and over and over again, as recently as 4 years ago, citing Roberson. So in that sense, I think Roberson is good law. But and maybe we should spend a few minutes just talking about this. Passion, feeling about the right to privacy. So much of your book, by the way, and again, I just want to commend everyone who's listening to see this book. We're just talking about one chapter. Everything old is new again, right? Nothing new under the sun. The right to privacy today is, needless to say, as fiercely debated, as passionately felt about, if not more so, than in 1902, because of the growth of constitutional law, which in 1902 did not, for all intents, certainly federal constitutional law, didn't contemplate a privacy right in 1902, or at least the United States Supreme Court recognized it. But over the next 120 years, we have seen a right to privacy embraced by the Court of Appeals in a variety of different contexts and settings, including private consensual sexual conduct. Same-sex marriage is now a recognized constitutional right, so says the U.S. Supreme Court. How we die, the right to die, is also recognized in particularly in some states' courts as a matter of constitutional dimension. And of course, reproductive rights, the right to terminate a pregnancy, which after Roe versus Wade was a federal constitutional right for 50 years until the United States Supreme Court just this past year, several months ago, in Dobbs versus Jackson, Women's Health overruled Roe. triggering widespread objection, protest, and discontent. And so the right to privacy, that case in Roberson, fast forward 120 years, is debated as fiercely as it was then, and all the issues that you so aptly described, Bruce, about should it be the legislature or should it be the courts? Well, the United States Supreme Court, in a divided opinion, just struck a different balance than that same court did 50 years earlier in Roe versus Wade. But all these other issues are still there, still debated.
Yeah.
Anyway, your thoughts?
No, I agree. That's well put. I agree 100%. The only thing I might add is that technology plays an intensifying or accelerating role in this. And so this might not have been a great issue till you got cameras. Well, then pretty soon you have movies. And there were some cases, I don't recall anything specific, where somebody went out with a movie camera and took a picture of people getting onto the subway in New York City and then put it in a commercial film. Well, is that an invasion of privacy? There was a case, I apologize, can't remember what it was, what the outcome was. They didn't ask people's permission. And then later on, things went on in computers and then the internet and the web. So if I take Abigail Roberson's picture here and spread it over the web, I won't have to do that because it's already up there. Is that an invasion? It's, I don't know how to put it. It's one of those things where technology races ahead and public opinion is all over the place. Sometimes racing ahead of government, I think. And then people think, well, gee, the courts better come and sort all this out. And they do that because the courts are generally regarded as the institution you can trust. I mean, I think you can trust most of government, but a lot of people today say, oh, you can't.
Right.
You can't be sure what governors, presidents, and the Congress and legislature is going to do. But the courts are sort of the last resort, the last stop, the last bulwark. And I think that's fair to say. I might just add here, in all my research, in this case and other cases, again, I'm talking about New York State, 1900, 1920, the judges were extremely conscientious. The opinions are very thorough, and I urge people to read them. I think they were written for the general public as well as for other lawyers and judges. And so it's an impressive situation. On the other hand, in 1907, entirely different context, Governor Charles Evans Hughes, speaking in a different venue about a different thing, made the comment that, yes, we have a constitution, but the Constitution is what the judges say it is. Now, he later tried to walk that back, and what he meant was you could trust the judges to guard the Constitution and so on, but it didn't come out that way. And that's been quoted over and over again, including later on when Hughes went to the Supreme Court, which he did, and then he was off for a while, ran for president, Secretary of State, and then became Chief Justice of the United States. We have a Constitution, but it's what the judges of the courts say it is. Some people conclude from that and other things, well, the courts are pretty arbitrary. I guess I don't feel that. I was probably less surprised by the Supreme Court's, some of the Supreme Court's recent decisions than other people were, because I think the Supreme Court has reversed itself over 200 times in its history. It isn't that uncommon. I mean, that's over hundreds of years, thousands of cases. And so if you want to secure a right, really nail it down so it can't be taken away, legislation will probably do it, but might not, because the court will throw it out. All it will do it is amend the Constitution. That's easy to say, pretty hard to do for some of these major issues where today in particular, there seems to be such deep-seated, almost not really violent, but confrontational divisions among people. Let me go to the next slide. I want to say this before I leave. There's an excellent journal, which I think Josie mentioned, going in, called Judicial Notice, published by the Society for the History of New York Courts, co-sponsor of this event. And this is an article by Daniel Kornstein that I think Hank alluded to early on. I think it's 2006, on this same case. It's a nice article. Not in depth, but a very good article. There's Chief Judge Parker, whom you recognize by now, and here's Abigail Roberson, who you'll recognize by now. So that tells you, among other things, these issues keep coming up, and they are discussed and debated in the legal community to some degree, as much as I might like in the history community, but they're not discussed and debated as much as they ought to be, in the way they ought to be, in the broader media and the broader press. So when a decision comes out, a lot of commentators say, "Oh, see, there they go again. You know, gosh, you can't trust them, and there was this appointee and that president, and so on." And that isn't quite the way it is. Courts have always been on the hot seat, if you will, and sometimes they go one way, sometimes they go another way. And like it or not, it probably shouldn't surprise us.
What I love about your book, Bruce, and why I think it's important, is that your description of the Court of Appeals in the early part of the 20th century, it was an institution, exactly as you said, that an issue after issue was addressing the most contentious, controversial, hot-button issues of the day, which are contentious and controversial today. Right. And oftentimes decided cases by divided votes, and yet its rulings, while oftentimes criticized, were ultimately accepted by the public and the electorate and respected. And so much of the cynicism that one sees, at least in terms of public commentary about some courts, one did not see as directed towards the Court of Appeals then. People objected to their decisions, controversial though they were, but the institution's reputation kept growing and growing and growing, and is immense. And I'll just one editorial comment, and I say this as a legal historian, as influential as the court was in 1902 and throughout the progressive era, it continued to grow in the 20s, 30s, and 40s, in the 20s and early 30s under the leadership of Benjamin Cardozo, who, unlike Judge Parker, had a more robust and expansive view of the common law. And you know, your excellent point about technology and the law, Bruce, in 1916, 14 years later, Judge Cardozo wrote an opinion in a case called McPherson versus Buick, which was the quintessential case of technology causing courts to change the law. And that technology was the automobile. And the epidemic of car accidents that were occurring across the state and the nation. And the question was whether manufacturers of automobiles could be sued for negligence. And prior to McPherson, the answer was no, because there was no privity between the purchaser of the car and the manufacturer itself. Mm-hmm. And the Court of Appeals, through a divided opinion by Judge Cardozo, said the law must be stable, but it cannot stand still. It must recognize that people who are injured have recompense. And so I think all of us owe an enormous debt to you for this look of this great institution at that period of time. It really is, in my mind, it should be required reading for anyone who wants to know how a judicial institution can deal with difficult issues that are contentious and yet command the respect of the public, even those who don't agree with a particular result. But Bruce, we have a minute or two or a moment left.
All right.
Thoughts?
So I think we have a few questions. It is 1:30. So I would just want to throw a couple questions at you really quickly and see if we can, we probably won't be able to get to all of them. But we did have a question about whether there is case law addressing the use of someone's face for advertising and whether that has value as an asset in their estate. So are copyrights available for facial photographs? And the person specifically mentioned, for example, the Gerber baby. Would that be something that would be considered part of the family's estate?
I don't know.
Yeah, well, I'll say a couple of things. I'm not a trust and estates lawyer, but I am quite certain that the Gerber baby, that image, if it were used today, whoever's child that was would have to consent to the use of that image for marketing and advertising purposes, and almost certainly be compensated for it. We have a whole industry of people who depend on their image for their livelihood, and that law protects them.
Great. Have there been any other cases in which, so someone mentioned the New York Court of Appeals declined to establish a right to assisted suicide a few years ago, stating that this was an issue for the legislature. Between Roberson and that case, have there been any decisions by the New York Court of Appeals that created new common law rights?
In many spheres, the Court of Appeals has been bold and expansive in terms of extending the law to deal with new technologies and frontiers. Privacy just has not been one of those areas, with one exception that I'll describe. For example, the New York Court of Appeals did not recognize a constitutional right to same-sex marriage, which was argued as a privacy right. It was a divided opinion. Judge Kaye, my former boss, I clerked for her, wrote a magnificent dissent, but it was just a dissent. So they didn't recognize that. Roberson continues to be, and by the way, I think that just reflects over the course of 120 years, a perception that privacy is such a complicated issue, the legislature is an institution more facile and nimble to draw lines and deal with that. What I would say, though, about the Court of Appeals, that they were a trendsetter in the privacy sphere, had to do with the ability to deny, for example, there's a case called Schlowendorf written by Judge Cardozo, which involved administering a drug involuntarily to a patient or a surgical procedure on a patient in an involuntary way. So the court has been very protective in that sphere, right? You know, there's a case called Matter of Storer, which, if memory serves, involves someone who lacked the intellectual ability to make an independent decision. And the question was whether or not some procedure should be administered over the objection or will of a patient, right? But I would say on the whole and by and large, the court has been in the privacy sphere very cautious and careful and incremental, unlike other areas of the law.
We'll just take one more question just for those people who are able to stick around. You mentioned that New York State, that other states have different laws relating to privacy. What are some of those states? Are there other states that have common law rights to privacy that New York State does not have?
Well, again, Hank's probably better qualified than I am to answer this. I think the answer is yes. That I don't know if the majority of the states, a lot of states have evolved a common law right to privacy through their courts doing what the New York State Court of Appeals has so far been unwilling or unable to do. That is, establish that through a series of binding decisions. But I don't know, I don't have anything specific on that, sorry.
Thank you so much, Hank and Bruce, for this insightful presentation today. And thank you to everybody who was able to join us. It is our privilege to make these events available to you and to keep New York State's history alive. If you're interested in the content we create and would like to see some more of it, please contact us at aptrust, at nysed.gov to receive a free past issue of New York Archives magazine. And I do want to let you know we have 2 exciting events coming up in November. On November 1st at 7 o'clock, we have our Empire State Archives and History Award program with Secretary of the Smithsonian Institution, Lonnie Bunch, and historian Harold Holzer, and that is going to be a great event. I highly recommend it. And on November 15th, please join us at 12:30 for our next New York Archives Magazine online speaker series entitled Immigration is Key to the Future. Upstate New York Demonstrates, with author and attorney Scott Fine, Rockefeller Institute of Government Center for Law and Policy Solutions, and Whiteman, Osterman, and Hanna, LLP. And you can visit our website at www.nysarchivestrust.org to find out more about these and other events and to register. And again, thank you so much, Hank and Bruce. And
Thank you.
everyone.
Such a pleasure. Thank you.
Have a great day.
All right.